Hearing the meeting on the Queen on the application of Bancoult number 3 and the Secretary of State for Foreign Affairs.
Mr. Covert.
Lord, I will continue with my plan, but I'll try and finish off the witness statements as quickly as possible.
Thank you.
We're on Mr. Roberts number 3, volume 2, page 750.
Yep.
This deals really with the fishing rights aspect. He sets out the background in the earlier paragraphs, and above paragraph 8, page 753, he has the heading UK-Mauritius bilateral talks. Early 2008, at the instigation of the Mauritian Prime Minister, the British Prime Minister had agreed to a dialogue between the FCO and Mauritian representatives on issues relating to buyout. Part of my directorate's role was to create a framework for these talks. We were very clear that sovereignty was a red line issue, but endeavoured to find other issues we could discuss with the Mauritians in order to have a worthwhile agenda. One of the issues identified, among others, was fishing rights as reflected in the correspondence within the FCO and with Mauritius in 2008 advice to ministers. What we had in mind under the rubric of fishing rights, and the only proposal we were prepared to advance with Mauritius at the talks on buyout, was practical cooperation such as sharing fisheries research and data on a joint observer programme as you have with the Seychelles. He refers to the British Fisheries Commission had been set up under a sovereignty umbrella in 1994, but the Mauritian side had walked away because, as I understood it, they considered it inconsistent with their position on sovereignty over buyout. And then skipping to the last few lines, these possibilities were never developed with Mauritius because, as I will shortly explain, it was made clear to us by Mauritius in the talks in January 2009 that it was only interested in fisheries concessions as a way of establishing sovereignty. It had no proposals to make under this heading, and the issue was not pursued by either side. And then, skipping a paragraph, the heading, the first round of the bilateral talks took place in Mauritius on the 14th of January 2009 under a sovereignty umbrella. I was the head of the UK delegation, which included Ms Yeadon. The Mauritius delegation was led by their Secretary to the Cabinet, Mr Siebeluk, and comprised, in addition, the Mauritius Solicitor General, High Commissioner to London, the First Secretary from the High Commissioner, and Mauritius's legal counsel, the late Professor Brownlee. And I will take you, when I've got over the witness statements, to the document that Professor Brownlee presented at that meeting. We allowed Mauritius and its counsel to present its case on sovereignty, which is also set out in the paper. The focus of the Mauritian presentation was sovereignty. Fishing rights were raised by Mauritius Council along with resettlement, rehabilitation of the economy of certain islands, protection of the environment and the resources of the continental shelf as an aspect of the exercise of sovereign rights of Mauritius based on their argument that they had sovereignty over buyout. The 1965 Lancaster House talks and the arrangements which resulted were referred to separately, first to reject them as a basis of agreement for the excision of buyout, and secondly as the basis for an alternative legal framework to sovereignty and a recognition of the legal interest in Mauritius in buyout. It was not claimed that Mauritius had legally enforceable fishing rights and or a right to free licences as a result of the 1965 undertakings. Rather, it was suggested in Council for Mauritius paper that it would be entirely fitting for the present talks were to involve offers from the UK side which reflect the content of promises which appear in the record. And as I say, I'll take you to that document later. The UK delegation said we did not accept Mauritius' case, but we would be happy to talk about other aspects of buyout, and then he refers to the record. And I can skip forward now to paragraph 14, consideration of the nature of Mauritian fishing rights. I did not take a view in late 2008 or early 2009 on the precise legal nature, if any, of the licensing arrangements for Mauritius-flagged vessels, but I did recognise that this was something we needed to look at as part of the scoping process for the MPA proposal. The question of what rights Mauritius had, if any, stemming from the 1965 understanding struck me as unclear, but by 2008-09 there did seem to be some kind of political commitment to issue free licences to Mauritian-flagged vessels who applied for licences under the fisheries regime then in force. I thought it necessary to confirm with the FCO legal advisers that the establishment of a no-take MPA would not conflict with any legal obligations owed by the UK to Mauritius. Towards the end of January 2009, advice was sought from SCO legal advisors on all legal issues potentially arising out of the Buyout Marine Park. We went back to legal advisors on several occasions over the following months to seek clarification on aspects of the legal advice received and as new questions arose. A legal advisor accompanied the delegation to the second bilateral talks in July. Thus, my understanding of the legal nature of Mauritius fishing rights firmed up over a period of time prior to the finalisation and launch of the consultation document. The defendant does not in these proceedings waive privilege in respect of any of this legal advice. And then he has further paragraphs about the 2009 talks, and I can skip to paragraph 19. In the run-up to the second round of bilateral talks with Mauritius, my firm understanding, as a result of the inquiries undertaken as part of the MPA scoping process and advice received from legal advisors, was that Mauritius did not have legal rights to fish in buyout waters, whether as a result of the 1965 understandings or otherwise, which prevented HMG from establishing an MPA, including a complete no-take MPA. If there was a fishing right, it was no more than for Mauritius-flagged vessels which applied to the Buyout Administration for licences to be issued them free of charge, but only insofar as the Buyout Administration chose to issue licences. Her Majesty's Government reserved the right to decide whether or not to issue a licence. In the case of a regime where no licences were issued, the questions of a free licence simply would not arise. And then above paragraph 20, there's the heading, the second round of bilateral talks in July. And he goes through that. I can skip to paragraph 22. The Mauritian Prime Minister's Chief Cabinet Secretary, who was hosting the formal bilateral discussions, also invited me for a tete-a-tete directly beforehand. We met for about 30 minutes, during which time I also discussed the possibilities of a buyout MPA with him. He did not mention fishing rights under the 1965 understanding or free licences issued to Mauritian-flagged vessels. And then skipping to 24, there was a short discussion under the heading of fishing rights which had been tabled on the agenda by the Mauritians ahead of time. The Mauritians wanted us to consider joint issuing of fishing licences, but this, we understood, related not to Mauritius fishing rights. It was not about fishing, but about the licensing process, but their wish to establish a sovereignty win. And it was commented in the Overseas Territories Department record of the discussions, all a bit surreal when we spent the last half-hour discussion on the possible ban of any fishing in the territory, but the Mauritians wanted this to remain an agenda item. We agreed to consider the item, but we need to take into consideration the implications of a proposed marine protected area. And I can skip to 28. If any one of the Mauritian representatives we spoke to on the 21st of July thought Mauritius had rights that would be interfered with by a possible MPA, including a complete no-take marine reserve, it is bizarre that they did not raise this in the bilateral talks or either of the meetings held that day, which were an obvious opportunity for them to do so. The fact that Mauritian officials never raised fishing rights as a significant factor reinforced my understanding that Mauritius did not have any such legal rights, and nothing that was said by Mauritian officials caused our legal advisor, who was present throughout as a member of the UK delegation, to amend or alter the legal advice we had received previously. And then there's a heading, subsequent relations with Mauritius, and I can skip to 30. Because of the time constraints imposed by the anticipated United Kingdom general election in 2010, the decision was taken to go ahead without Mauritius' involvement with the public consultation. The public consultation document was prepared and finalised by Ms. Yeadon, launch date of 10th of November. Mauritian fishing rights, or the possibility of Mauritian fishing rights, were not included in the consultation document because as far as we were concerned, Mauritius did not have any. And then the next heading, Mauritius and others' responses to the public consultation. He notes that no representation was made on behalf of Mauritius or anyone else in the period between the launch of the public consultation on the 10th of November and the Foreign Secretary's decision. And I'll take you to the bilateral representations that Mauritius did make to the UK. And then in 33, I was aware that during the period of the public consultation, it had been made clear on behalf of Mauritius on several occasions that its government was unhappy with what was seen as a unilateral FCO consultation, and that they had demanded that the MPA consultation be cancelled before they would take part in any further rounds of talks. But at no time was any claim made on behalf of Mauritius that an MPA, full, take or otherwise, would interfere with any legal rights stemming from the 1965 understandings of licences for Mauritian flagged vessels. This is reflected in the advice we submitted to ministers on the 30th of March on the proposed MPA next steps, which included a lengthy section on Mauritius. That advice made no reference to any 1965 side agreement with Mauritius, as had my briefing on the large-scale marine reserve on the 5th of May, because we were by then satisfied that it was simply not an issue. And then at 36, as is evident from the internal correspondence of the 31st of March, and I'll take you to that, generated in response to the Foreign Secretary's request for additional information produced at the negative reaction we anticipated from Mauritius to a proclamation of a full no-take MPA was perceived to be a political problem and not a legal one, and that refers to the distinction mentioned by Lord Sumption yesterday about the distinction between legal and political risks. Then 37, as anticipated, Mauritius did react negatively to the news of the proclamation. However, as the record of the conversation on the 1st of April shows, the Mauritian Prime Minister did not at any point claim that the MPA would infringe any Mauritian legal rights stemming from the 1965 understandings or right to free licences of Mauritian flagged vessels, nor did a note verbal received from the Mauritian Foreign Ministry dated the 2nd of April formally protesting the proclamation of the MPA. And then in 38, there's a heading, the Chagossian aspects. As to the Chagossian aspects, my understanding throughout was that the arrangements to issue licences free of charge applied only to certain Mauritian flagged vessels. And in 39, to conclude, there was no reference to any historical or traditional fishing rights of Mauritius or the Chagossians, which might stem from the 1965 understandings in the public consultation, or the possibility that any rights might exist, because after considering the question and receiving legal advice, we did not believe that Mauritius or the Chagossians had or might have had any such rights.
Am I right that that's what the award has actually held, that insofar as there was an express agreement, it was related to Mauritian flag vessels?
Yes, there is nothing in the arbitration award about Chagossians as Chagossians having any rights.
But equally, the award didn't deal with what might be traditional fishing rights, whatever they may be.
Yes, I mean, I handed up a speaking moment yesterday. It may be a convenient moment to take you through that now, though I was going to do it in the chronology of the contemporaneous document, so I was going to basically go through the first 7 months of, go through 2009, 2010, and then go to the award. But if you want me to take you through the award now, I can do that.
No.
All right, I'll do it chronologically. There's Mr. McManus' statement. I'm conscious Lord Mance at least has read it. That really goes into the nuts and bolts of the fishing. I'm prepared to take that as read by the court rather than taking up any more time on that. In answer to Lord Clark's question yesterday, which I failed to answer, demersal, and I only found this from Wikipedia, means bottom feeder.
Thank you.
Right, if I can then move on to the contemporaneous documents.
So Wikipedia is it.
We start here with the bilateral talks in January 2009, and this is volume 2, page 478. As you will recall, Mr. Roberts made reference to these in his third statement. 478 is the communique, and I can skip the first paragraph. Delegations discussed the latest legal and policy developments relating to the British Indian Ocean Territory / Chagos Archipelago. Mauritian delegation set out its view of Mauritius on sovereignty. British delegation set out its view of the UK on sovereignty, and you'll see if you go through these documents, this is somewhat of a mantra. There was also mutual discussion of fishing rights, environmental concerns, the continental shelf, future visits to the territory by the Chagossians and respective policies towards resettlement. the two delegations agreed the need to maintain a dialogue on a range of issues to the territory and to meet again. And then there's a further reference to the sovereignty umbrella procedures. And then on the right-hand side, page 479, you have the notes of the talks on January. And I think Mr. Fleming took you to that, but I might be wrong about that. But I can pick it up at 482. And you'll see there's section 6, access to natural resources, number 1, fishing rights. And there's a quotation. I'm not sure it's true anymore that the fish die of old age in the Indian Ocean. Then the final paragraph, the Mauritians explain that their lack of interest in taking up fishing rights, brackets, free licenses, close bracket, and continuing with the British Mauritian Fisheries Commission was that they felt this impacted on their position on sovereignty. And that, I think, is all I need from January 2009, apart from, before I go to the Brownlee paper, which is at 468. My submission on the Brownlee paper is this, is what he does is he sets out as his primary case the sovereignty arguments that were familiar to everybody. And then he sets out what he calls an alternative case, an alternative legal framework. And we say that that is no more and no less than an alternative based on the fact that, as Mauritius would put it, they have at the very least reversionary rights. And therefore it's in light of their reversionary rights that we ought to be talking to them about a range of issues, including fisheries. But I'll try and take you through the document as quickly as I can. 468 in volume 2, it starts. And he begins by saying, in order to have a constructive dialogue, it's necessary for the UK sides to understand the legal framework. And then the next paragraph, it is a position that Mauritius enjoys sovereignty, that all that's been deferred. And that's then his primary argument about sovereignty. And then if we skip to 472, towards the bottom, he says, I now turn to an alternative legal framework. And over the page, whatever the legal position in the second paragraph, the Lancaster House talks do provide an alternative framework which represents the position adopted by successive governments in the United Kingdom over a long period of time. This position includes a series of inducements. The existence of these promises is obvious. Records available contain a substantial quantity of evidence that the British side offered promises of reversionary rights. Important because even if the Mauritius delegation gave their consent to the proposals, they were accepted on the basis of certain understandings. The evidence of the promises of reversion includes the following. Then he sets out an extract from the 1965 undertakings. I'll skip that because I'm going to take you to the actual document soon. And then he goes on at 476 towards the bottom, after the quotation. In this context, it's necessary to accept the link between the British proposals of 1965 and the subsequent undertaking to cede the Chagos archipelago. And then he refers to a letter written by the then Prime Minister, Mrs. Thatcher, and that's where he picks up on the word revert. And just as a footnote, that is the sole use by the British side of the word revert as opposed to cede when no longer required for defence purposes. But understandably, Professor Brownlee has seized on that. And he says, of course, a policy of reversion would do no more than to restore to Mauritius the enjoyment of the rights of sovereignty which inhere in Mauritius, legally speaking in any event, full stop. However, such undertakings do involve an indirect recognition by the United Kingdom of the legal interest of Mauritius in the Chagos. Conclusion to be drawn from the evidence relating to a reversion is that even within the framework of the Lancaster House talks, promises were given which formed part of the inducements offered to the Mauritian leaders seeking independence. It's thus entirely fitting if the present talks were to involve offers from the UK side which reflect the content of the promises in 1965. And then, in closing, without prejudice to sovereignty. So that was the paper presented by Professor Brownlee on behalf of Mauritius, which I say is entirely consistent with, based on raising fishing as part of the sovereignty dispute and in its alternative framework as part of its reversionary rights. So that was January. Then in March and April, there were two notes verbal from the Mauritian side, the same volume 2, 489 and 490. First, 489 is the 5th of March, and you'll see the central paragraph. The protest is on the grounds of sovereignty. In the Chagos Archipelago is under the sovereignty of Mauritius, and the denial of the enjoyment of sovereignty in Mauritius is a clear breach of the UNGA and international law. The creation of a marine park in the Chagos Archipelago will therefore require on the part of all parties that have genuine respect for international law the consent of Mauritius. Same point, it's a sovereignty objection is made in the note verbal over the page of the 10th of April. All sovereignty, it's not about fishing rights. The next document chronologically is Mr. Roberts' submission of the 5th of May, and you looked at that in some detail yesterday, and that starts the next page in the bundle, 491.
Yep.
And I needn't take you through that in any detail, save to say that as the court observed yesterday, it identifies the risks that are political and addresses those. And it's in that context that there is a reference not only to sovereignty, but to other matters as well. So that's May. That results in the go-ahead from the Secretary of State to proceed with the MPA proposal. Chronologically, the next documents are in relation to the bilateral talks in, chronologically, the next thing is July 2009, and this is the FCO investigation into what, if anything, was meant by the fishing rights. And this is bundle 2, starts at 508.
Thank you.
It's a chain of emails, so the first email we need to read is on 509. It's the 3rd of July email from Mr. Roberts, begins halfway down the page.
Right.
And that's a request for advice on what the fishing rights means. Miss Yeadon then gets advice from MRAG, which is at 512, and that's dated the 6th of July. And that also attaches tables showing licenses. You need to read the tables with some care because it shows Mauritius fishing activity, because it includes Mauritius owned as well as Mauritian flag vessels. So it's not strictly the vessels. But you'll see the first one is inshore fishery, and as Mr. McManus's statement explained, and as I got wrong yesterday, it's the inshore fishery which uses the dory boats, and that's what Mr. Volley and Mr. Sakir have been doing. The long line and the purse seine fishing is deep sea fishing for tuna. So those, you see the number of licenses. Inshore fishery, you'll see 2005 0, 2008 0, and the small numbers in other years. The footnotes explain about the involvement of the Talbots and reflagging their vessels. The table over the page is the purse seine fishery, and you'll see notably that there's nothing at all after 1999. That then results in the email from Miss Yeadon to Mr. Roberts of the 14th of July, and that's the one on 508.
What?
508.
508.
Yep.
Colin, Mauritian fishing rights were never defined in the Lancaster House side meetings, but what it boils down to is free access to Biot waters. This has translated over the years to the Mauritius being obliged to apply for a permit, but getting it for free. You've already seen the research analyst's 1996 paper on the history of fishing, and now Chris Meese, he's MRAG, has provided a snapshot in his recent paper on the marine park. I'll also send a copy. So that was the advice that Miss Yeadon, having carried out her own investigations, gave to Mr. Roberts. And it's on the basis of that advice, amongst others, that Mr. Roberts says what he does in his witness statement. Chronologically, the next step is the July 2009 bilateral meetings, and we can pick those up at 515.
Yep.
21st of July starts off by referring to the usual sovereignty umbrella. The first topic above paragraph 3 is sovereignty, and then above paragraph 8 we get environmental issues, and at paragraph 10 on 517 the Mauritian delegation explained that they had taken exception to the proposal from the Chagos Environmental Network, but on the basis that it implied that the Mauritians had no interest in the environment. They had also found it necessary to protest on scientific grounds. A general agreement that scientific experts should be brought together. However, the Mauritians welcomed the project but would need to have more details and understand the involvement of the Mauritian government. The UK delegation explained that not many details were available as the UK wanted to talk to the Mauritians before proposals were developed. If helpful, the UK could, for the purposes of discussion, produce a proposal with variations on paper for Mauritians to look at. UK delegation added that the Foreign Secretary was minded to go towards a consultative process and it would be a standard public consultation. However, the UK had wanted to speak to the Mauritians about the ideas beforehand. Also, we needed to bear in mind the case before the European Court of Human Rights. Any ideas proposed would be without prejudice to any judgment by the court. And then access to fishing rights, and this is what Mr. Roberts was referring to. There was a short discussion about access to fishing rights. The Mauritians wanted to manage jointly the resources. This was simply put on the table for the UK to consider. Comment. This all seemed a bit surreal when we'd spent the last half-hour discussion on the possible ban of any fishing in the territory, but the Mauritians had warned us that this would remain an agenda item. We agreed to consider the idea, but would need to take into consideration the implications of a proposed marine protected area. And you'll see it over the page that Ms. Yeadon is the author of that note of the meeting. Next in time is the consultation document itself. That begins at 521. You'll see it includes a forward by Mr. Miliband. Then the consultation questions are set out on 525, including at 4, any other measures be taken to protect the environment. And then scope at 527, any decision to establish a marine protected area would be taken in the context of the government's current policy on the territory following the decision in Bancoult No. 2 and the 2004 order, i.e. there is no right of abode in the territory and all visitors need a permit to enter. Access to a part of the territory is also restricted by our treaty obligations with the US. It is the government's provisional view, therefore, that we would not establish a permanent research facility in any part of the territory. Any decision to establish a marine protected area would not affect the UK government's commitment to concede the territory to Mauritius when it's no longer needed for defence purposes. Consultation and any decision that may follow are of course without prejudice to the outcome of the current pending proceedings before the ECHR. This means that should circumstances change, all the options for a marine protected area may need to be reconsidered. And then at 531, there's impacts, costs and benefits as Annex A, and under benefits, the first thing is the hyperlink to the report of the National Geography Centre workshop that Ms. Yeadon mentioned in her statement. Then there's the paragraph I took you to yesterday with the reference to footprints. And then impact over the page, and it has subheadings for the US and for Mauritius. And in relation to Mauritius, the joint communique from the 2009 talks, which are set out as Annex C at 535. And Annex C at 535, both delegations reiterated their respective positions on sovereignty and resettlement as per January. And then skipping a couple of paragraphs, the British delegation proposed that consideration be given to preserving the marine biodiversity and waters surrounding the Chagos Archipelago / British Indian Ocean territory by establishing a marine protected area in the region. The Mauritian side welcomed in principle the proposal for environmental protection and agreed that a team of officials and marine scientists from both sides meet to examine the implications of the concept with a view to informing the next round of talks. The UK delegation made it clear that any proposal for the establishment of the marine protected area would be without prejudice to the outcome of the European Court of Human Rights. And then skipping a paragraph, both sides agreed to meet on a date to be mutually agreed. Now, that paragraph, those paragraphs had already been amended in light of a protest by Mauritius, but as we'll see, there were further protests from Mauritius about that. Going back to 533, another of the subheadings under impact is the Chagossian community. Again, it refers to Bancoult number 2. The current position under the law of Biot is that there is no right of abode in the territory. All visitors need a permit. Under these current circumstances, the creation of a marine protected area would have no direct immediate impact on the Chagossian community. And we respectfully submit that that is an entirely correct statement. Insofar as there was any fishing, it was done as Mauritians. As so far as Chagossians were Chagossians, it was the right of abode that was relevant, directly relevant. However, we recognise that circumstances may change, and following any rule that may be given in the Strasbourg proceedings, circumstances may also change when the territory is ceded to Mauritius. In the meantime, the environment will be preserved and protected. And then there's the policy on marine protected areas at Annex D at 537, which I needn't go through. Next, can I ask you to put down bundle 2 for the moment? Next, I want to take you to what Mauritius said bilaterally to the United Kingdom during the course of the consultation period. And we can find that most conveniently set out in the arbitration award in bundle 4. And if I could ask you at bundle 4 to turn up page 1301 and paragraph 131. Now, the course of what Mauritius was saying to the UK and vice versa during the consultation period is set out from paragraphs 131 to 147 inclusive. And can I commend that you read all of them? I won't take up time going through them all now. Can I just highlight a few points? And what I'm highlighting is that there is nothing in this about fishing rights distinct from sovereignty. Paragraph 131, there's a phone call when the consultation is launched from the Foreign Secretary, the UK Foreign Secretary, to the Mauritian Foreign Secretary, and it's the last of those paragraphs setting out, summarising the phone call. In addition, Mr. Ram Ghulam said the consultation document completely overlooked the issue of resettlement. A total ban on fishing would not be conducive to resettlement, neither was there any mention of the sovereignty issue. Prime Minister Ram Ghulam did not want the MPA consultation to take place outside the bilateral talks between the UK and Mauritius. And then on page 1302, the second paragraph, PM Ram Ghulam repeated the point that a ban on fishing would be incompatible with resettlement. And then I can skip to 134, 23rd of November. Mauritius wrote to the United Kingdom. Third paragraph of that. Furthermore, the Ministry of Foreign Affairs, etc.
Which page?
Sorry, 1303. So it's paragraph 134 of the award, the 23rd of November Mauritian letter, third paragraph of that. Furthermore, the Ministry of Foreign Affairs would like to state that since there is an ongoing bilateral Mauritius-UK mechanism for talks and consultations on issues relating to the Chagos Archipelago, and a third round of talks is envisaged early next year, the government of the Republic of Mauritius believes that it is inappropriate for the consultation as far as Mauritius is concerned, to take place outside this bilateral framework. The government of Mauritius considers that an MPA project in the Chagos Archipelago should not be incompatible with the sovereignty of the Republic of Mauritius over the Chagos Archipelago and should address the issues of resettlement, access to fisheries resources and the economic development of the islands in a manner which would not prejudice an eventual enjoyment of sovereignty. Total ban on fisheries exploitation and omission of those issues from any MPA project would not be compatible with the long-term resolution of or progress in the talks on the sovereignty issue. And then at 136 on page 1304, there is Mauritius record of a conversation between Prime Minister Gordon Brown and Prime Minister Ram Ghulam on the margins of the Commonwealth Heads of Conference meeting. And as you'll see when you read this, this unfortunately involved a difference in recollection. 136 sets out the Mauritian record, and paragraph 35 of that, I stated Mauritius does not recognise the British Indian Ocean Territory and therefore we cannot even discuss the issue of a marine protected area with them. I emphasise that the issue of resettlement remains a pending issue and Mauritian fishing rights have to be taken into consideration. I therefore indicated that since bilateral talks were intended to deal with all issues concerning Chagos progressively, this is the venue we should continue to use for our further discussions. The British Prime Minister paid tribute to the leadership role played by Mauritius in the deliberations of the meeting, particularly on the issues of climate change from the perspective of the small island developing countries. On the issue of the marine protected area, he assured me that nothing would be done to undermine resettlement and the sovereignty claim of Mauritius over the Chagos Archipelago, and that he would put a hold on this project. And then Mr. Ram Ghulam made a further note, and that's 137 of the award. We can pick it up at paragraph 12 of that note. I further pointed out that the issues of sovereignty and resettlement remain pending and that the rights of Mauritius in the Chagos Archipelago waters had to be taken into consideration. In response, Mr. Brown asked me once again, what would you like me to do? I remember these words clearly. I replied, you must put a stop to it. There could have been no doubt that I was referring to the proposed marine protected area. Mr. Brown then said, I will put it on hold. And then at 138 sets out the different recollection of the UK side of the meeting, which I won't read out. And then at 140, then there's a further response from Mr. Boulel to the British Foreign Secretary, 30th of December, paragraph 140 on page 1306. Second paragraph of that, on the substance...
1406.
1306, sorry. On the substance of the proposal, I had conveyed to you that the government of Mauritius considers that the establishment of the marine protected area around the Chagos Archipelago should not be incompatible with the sovereignty of Mauritius. And then next paragraph, moreover, the issues of resettlement in the Chagos Archipelago, access to fisheries resources and the economic development of the islands in a manner that would not prejudice the exercise by Mauritius of its sovereignty over the Chagos Archipelago are matters of high priority for the government of Mauritius. The exclusion of such important issues in any discussion relating to the proposed establishment of a marine protected area would not be compatible with the issue of sovereignty. In these circumstances, as I have mentioned, Mauritius is not in a position to hold separate consultations with the team of experts on the UK to establish a marine protected area. You will no doubt be aware that in the margins of the CHOGM meeting, Prime Ministers agreed that the marine protected area be put on hold. And then Mauritius put in a note verbal the same day. Mauritius considers that the next rounds of bilateral talks cannot take place during the month of January in the absence of satisfactory clarification and reassurances on the part of the Government of the United Kingdom on the issues raised on the 23rd of November. And then on the 13th of January, the Foreign Minister called on the British High Commissioner. High Commissioner's note is set out in 142 on page 1307. By far the biggest issue was the outcome of the PM Brown, PM Ram Ghulam tete-a-tete. Ram Ghulam had briefed Cabinet following the meeting at CHOGM and told them that Brown had agreed to drop the consultation. He was very and unusually clear and definitive about this, and had clearly expected Brown to make some sort of statement to this effect. Brown also briefed the press on the matter and took pride in pointing to this result as stemming from his good relationship with Brown. Boulel noted he had a soft spot for him. As the days wore on after the summit without a statement, Rangoon became increasingly frustrated. When Miliband's letter arrived, which we had written thinking it very conciliatory, Rangoon took this as a kick in the teeth. Ramgoolam's anger triggered the notes of the 30th December, and upon Rangoolam's instructions, a press briefing by Boulel earlier this month. Some of these points are manageable, but the discord between Ramgoolam's readout of the PM's meeting and the readout from Brown is clearly large and in many ways insurmountable. I detected no sense that the Mauritians are playing a game on this. Ramgoolam clearly believes Brown promised him what he had wanted and that somehow Miliband sought to circumvent this. I assured Boulel this wasn't the case and showed him the readout we had received from number 10. We both scratched our heads. I noted we needed a way forward. So you can see that there was a certain amount of bilateral friction going on at the time. And then on the 20th of January, paragraph 143, the British High Commissioner met the Mauritian Prime Minister, and the United Kingdom's note is set out at page 1308 there, and the third and fourth paragraphs. Looking forward, I explained how my goal in meeting the PM was to enable both sides to move forward. Skipping a few lines, was he sure that a letter would work? Ramgoolam pondered aloud about what he perceived as David Miliband's strong commitment to the MPA and whether recent political events in the UK might inhibit Gordon Brown from pushing Miliband to rein in the consultation even if he wanted to. I noted that I had been working with Boulel to draft a letter that might help both sides move forward. Boulel was keen for the PM to see it. I didn't want to send the letter until I knew it would help the situation. The draft answered all of Mauritius' concerns re-consultation, and with the government of Mauritius taking place through bilateral talks, sovereignty, non-prejudice to the settlement of the case at the ECHR, etc. Ramgoolam undertook to look at it with Ruhi. He was glad no other copies existed. Then 4th of February, paragraph 144 and 1309, Mauritius put in written evidence to the House of Commons Select Committee, and that is set out, and paragraph 2 says, since there is an ongoing bilateral Mauritius-UK mechanism for talks and consultations on issues relating to the Chagos Archipelago, it is inappropriate and insulting for the British government to pursue consultations globally on the proposal for an establishment of an MPA around the Chagos Archipelago outside this bilateral framework. And then paragraph 5, moreover, the issue of resettlement in the Chagos Archipelago, access to fisheries resources and the economic development of the islands in a manner which would not prejudice the effective exercise by Mauritius of its sovereignty over the Chagos Archipelago and matters of high priority to the governments of Mauritius. Paragraph 7, the existing framework of talks between Mauritius and the UK on the Chagos and related environmental issues should not be overtaken or bypassed by the public consultation launched by the British government on the proposed MPA. 8, the establishment of any MPA around the Chagos should also address the benefits that Mauritians should derive from any mineral or oil, and we'll see that's another matter referred to in Lancaster House that may be discovered. And then nearing the end, paragraph 145, 1310, 8th of February, British High Commissioner again met Foreign Minister Boulel. Second paragraph, Boulel raised the issue of Chagosian settlements and the meaning of "are without prejudice" phrase in the MPA consultation document. Skipping a paragraph, it was clear the Mauritians would not welcome the visit of the facilitator, and that was as part of the consultation process. They wanted to retain their sovereign rights, and then they said if we could set up a video conference. Then the next paragraph, we stated that if talks could be restarted, they'd be productive only if Mauritius came with a clear sense of what it realistically wanted, other than either A, demanding sovereignty as they had done in London, or B, dwelling only on those things that were unacceptable to Mauritius. Boulel took the point and raised a couple of issues that could be profitably discussed. Demarcation of the continental shelf, the terminology MPA, future PM-PM engagement, trilateral discussions with the US, arrest from nuclear ships visiting, but nothing about fishing. And then on the 15th of February, UK wrote to Mauritius referencing the note verbal of December, and And then the Secretary of the Cabinet in Mauritius responded on the 19th of February to reiterate the position of the government of Mauritius to the effect that the consultation process should be stopped. The current consultation, which is unilateral and prejudicial to the interests of Mauritians, withdrawn. Indeed, the consultation paper is a unilateral UK initiative which ignores the agreed principles and spirit of the ongoing Mauritius-UK bilateral talks and constitutes a serious setback to progress in those talks. Further inform you that the government of Mauritius that any proposal for protection of the marine environment of Chagos needs to be compatible with and meaningfully take on board the position of Mauritius on the sovereignty over the Chagos archipelago and address the issues of resettlement and access by Mauritians to fisheries resources in that area. Also wish to state Mauritius is keen to resume bilateral discussions. So that's what's going on between the UK and Mauritius during the consultation period. So you see they object to this being discussed in public as opposed to being a bilateral matter for the UK states. They reiterate their primary case on sovereignty, and they refer to fishing rights and other matters such as mineral and oil resources as part and parcel of the mechanics of their sovereignty claim. The next in the chronology is the arbitration. Now, this is in Bundle 4 as well, as we've just been looking at. The arbitration claim form was issued the 20th of December 2010. Don't turn it up, but it's page 1257, paragraph 14. And I handed out a speaking note which is intended to be a neutral summary of the landmarks of that. And I don't know whether you've had a chance to look at it, but I can probably simply take you through it now without referring to the paragraphs. If you do have it to hand,
Yes.
we can do with that. If you do want me to take you to the paragraphs, I would of course do so.
Well, I think assume we don't want you to unless somebody asks.
Yep. So you'll see Mauritius made 4 submissions at the arbitration. The first Mauritian submission was that the UK was not entitled to declare the MPA because the UK is not the coastal state, and the tribunal found that it had no jurisdiction to consider this submission because it was a claim for sovereignty and therefore out with the UN Convention on the Law of the Sea. Mauritius' second submission was that the UK was also not entitled unilaterally to declare the MPA because Mauritius was a coastal state. So you may think the other side of the coin from the first submission. And for the same reason, the tribunal decided it had no jurisdiction to consider that second submission.
Where it says no jurisdiction, that's not a statement of the submission, but...
No, that's the award. That's the tribunal's decision on the award. No jurisdiction to consider the submission. The third submission was that the United Kingdom could not impede Mauritius's submissions to the Commission on the Limits of the Continental Shelf, and the tribunal found that there was in truth no dispute between the UK and Mauritius on this, and therefore it was unnecessary for them to address it themselves. The submissions on the Continental Shelf could be done under a sovereignty umbrella, so no dispute. The fourth submission of Mauritius was that the MPA was incompatible with the United Kingdom's own obligations under Articles 2, 55, etc. of the UN Convention on the Law of the Sea. And in the dispositif, which is the operational paragraph at 547, and it may be helpful if we do at least turn up that paragraph because we can see what the tribunal actually decided. That's page 1467 of volume 4. .547 is the dispositive, and paragraph B, in relation to the merits of the parties' dispute, the tribunal having found inter alia 1, that the United Kingdom's undertaking to ensure that the fishing rights in the Chagos archipelago would remain available to Mauritius as far as practicable is legally binding insofar as it relates to the territorial sea, and we can ignore 2 and 3, declares unanimously that in establishing the MPA surrounding the Chagos archipelago, the United Kingdom breached its obligations under Articles 256 and 1944.
Where do we find them?
They are, the references are given in my note. So if you look at the note, they are...
No, it must be in the authorities.
Sorry, it's paragraph 11 of the notes. You will see Article 2 is paragraph 459, Article 56, 470, Article 194481. I can take you to them if you want, but the reference is there in the note.
And what's meant by the territorial sea here in B1?
It's essentially the 12-mile limit.
Just the 12-mile limit,
Yeah.
so that...
Yes, and you'll see that they deal with the
I don't think that's agreed on the other side, but we'll listen to them.
You'll see that they find that they have no jurisdiction over the 2,200-mile area for reasons that they explain. But yes, it is only the territory.
Yes, well, I mean, that's what one might normally understand, but it seemed odd.
Yes, but they do explain why. Mauritius was claiming for a lot more, but they were turned down on that. The speaking note continues. Paragraph 6 deals with this, that there was no jurisdiction to consider fishing rights in the exclusive economic zone because it was excluded by Article 2973 of the Convention. I give the reference to that. The tribunal also deals with the Lancaster House understandings, and that I deal with at paragraph 7. Paragraph 9, tribunal found it paragraph 8 is amplification of that in relation to the Lancaster House understandings. Paragraph 9, tribunal found it unnecessary to address any traditional fishing rights independent of the Lancaster House. Paragraph 10 deals with the WikiLeaks cable. And paragraph 11 found that it was procedural obligations in those articles of the Convention, effectively failure to consult fully and timelessly with Mauritius was the fault, as opposed to a substantive inability to declare the MPA. And I give the references in paragraph 11 of the note. And then in paragraph 12, the tribunal's final observation was that it was now open to the parties to enter into negotiations with a view to achieving a mutually satisfactory arrangement for protecting the marine environment, etc., to the extent necessary and under a sovereignty umbrella.
Did the tribunal focus on the point that you've been, I think, making, namely that Mauritius didn't assert that it had any fishing rights apart from the sovereignty issue? It criticised the UK for proceeding on the flawed basis that Mauritius had no fishing rights. Did it address the other side of that coin, which is presumably that Mauritius itself proceeded on what the tribunal concluded was a flawed basis, i.e. didn't raise any fishing rights?
No, is the short answer to that, it didn't. It did find that the Lancaster House undertakings had, in the events which had happened, become legally enforceable, and fishing rights were included in those. And as I say in paragraph 8 of the note, the tribunal spelled out to a reasonable degree what it meant by those fishing rights. So it does deal with fishing rights to the extent that I've identified in paragraph 8 of the note.
But did it examine the material which you've just drawn our attention to?
Not for the purpose of the exercise that I've been trying to draw a distinction between sovereignty as opposed to an independent claim to fishing rights. That wasn't the concern of the tribunal.
Was it argued?
I haven't been through the submissions, so I'd be reluctant to commit myself to whether anything was or was not argued. I don't think it features in the award as being argued as a distinct point.
And what's at the end of paragraph 8, where it refers to the UK's, quote, discretion in the routine management of the fishery? What's that a reference to?
Well, that is one of those phrases that gives the two parties, the UK and the Mauritius, scope to negotiate. It's not defined. So it's not a hard and fast black and white thing. Fishing rights means X.
Well, presumably, if there was an acute shortage of fish, or they were being fished out, the UK could say, we need to revive this area and no fishing for a year.
Yes, I think it is a fair inference that everybody, including the tribunal themselves, was aware that despite the quotation that I referred to earlier about fish dying of old age in the Indian Ocean, that is no longer sadly the case. And overfishing is a very real risk and may well require, even under the Lancaster House undertakings, limitations on the amount of fishing. So I strictly agree with Lord Mance. Yes, that's no doubt what they had in mind, but it's not spelled out what it actually entails. Yes, and when we look at the undertakings themselves, we'll see they themselves were open-ended. But just to follow through on the award, you'll see that at the end of the speaking note, I've got a couple of paragraphs on what's happened since. That was drafted before the UNGA resolution of last week. And you'll see that paragraphs 13 and 14 that there have been a number of rounds of bilateral UK-Mauritius talks on the award. Those talks stalled because Mauritius insists on fixing a date for the UK ceding sovereignty over Bancoult to Mauritius. So you'll see sovereignty is dominating, as I keep saying. The UK wants the talks to continue under a sovereignty umbrella. The UK assesses that Mauritius' interest in bringing the arbitration was to further its sovereignty claim. The arbitration now having concluded with the award, Mauritius has lost interest in bilateral talks and is pursuing its sovereignty claim by other means, and then that's the UN. The Mauritius also demands that the MPA be rescinded before progress can be made on consultation.
So that's what led to last week's decision?
Yes.
Yeah. And it may be to bring you up to date that I can read you out, and I say read out because it is an approved form of words. And I suppose it's also an attempt to get into Lady Hale's good books by giving her some notes to take, but that's probably in vain.
Well, you see, I have been taking notes.
The up-to-date position, my lords, my lady, is this. Her Majesty's government is committed to implementing the dispositif made in 2015 following arbitration between the United Kingdom and Mauritius over the marine protected area around the British Indian Ocean Territory. In line with the dispositif, the United Kingdom will continue to work with Mauritius to agree the best way to meet our obligation to ensure fishing rights in the territorial sea remain available to Mauritius so far as practicable. The arbitral award did not require the termination of the marine protected area, but the United Kingdom will continue to approach discussions with an open mind about the best way to ensure proper conservation management of this unique marine environment. If the court wants copies to be provided, I will provide copies.
Yes, I should like to have a copy.
Yes. And one of the reasons I have gone this is I'm conscious that Lord Mance raised a very pertinent question yesterday, which I no disrespect, I'm flippantly summarising as well. If you carve out fishing rights, can't we all agree and go home? But this is where we are, that there is negotiation that needs to be undertaken between the parties directly concerned, and those are the United Kingdom and Mauritius. But we will implement the award. That, subject to any questions from the court, my lord, the respondent's submission on fishing rights.
Well, could you summarise the actual case? You accept that at the very least there's a strong case for saying that there were international rights possessed by Mauritius. It wasn't mentioned. What therefore is the answer to the submission that there was a flaw in the consultation? You've been showing us a great deal of material relating to the consultation. Is the answer that Mauritius had ample opportunity of raising this point and never did? Is the answer that the rights are effectively de minimis or so small that they didn't need mention? What is the answer? It wouldn't have made any difference if they had been mentioned because Mauritius, the possessor of the rights, knew all about them and could have raised them if it had wished to do so, but its focus was on sovereignty and it was worried about the impact of viewing the matter in any other terms than sovereignty. What precisely, how do you put it?
Yes, well, if we look at the three traditional public law heads of reasonableness, fairness and legality, in terms of reasonableness, I submit that the material that I've showed you demonstrates that the defendant, through his officials, did make all reasonable inquiries and therefore complied with all Thameside type duties to make reasonable inquiry. And having made those reasonable inquiries, reached a reasonable conclusion that Mauritius had no legally enforceable fishing rights. They had a right stemming from the 1965 undertakings, which was political, which had developed over the years and had taken the form that if they applied for a licence, Mauritian flagged vessels wouldn't have to pay a licence fee, but it was no more than that. And that, as a matter of factual investigation and conclusion, were all reasonable. So we tick the box on the reasonableness head of public law challenge. In terms of fairness, the material I've showed you demonstrates that Mauritius had ample opportunity to put forward its claim, because if anybody had the rights, it was Mauritius. There was nothing unfair in the consultation progress. We did not inhibit Mauritius from advancing its position in any way, and indeed, insofar as we could, because Mauritius was actively telling us not to go public but to stick to bilateral means, we did go public by putting in the joint communique in the consultation document. And there was nothing unfair in the consultation about the extent or content of Mauritius's position in relation to sovereignty, fishing rights, or anything else. And in terms of legality, as the court is aware, the appellant has never been allowed to advance a case on legality in the sense that Mauritius could have enforceable fishing rights. It wasn't allowed to put forward that case, and that was the basis on which the case has always been conducted. Mr. Fleming in this court has disclaimed any attempt to resile from that concession, if that's the right word, even though actively in granting permission on the terms that it did, this court asked the parties to address that point. So I haven't addressed it on the basis that Mr. Fleming has made it quite clear he's not asserting that Mauritius has legally enforceable fishing rights, and therefore the legality in that strict sense doesn't arise. The arbitration award took place, of course, after the decisions that are under challenge in these proceedings. It doesn't retrospectively affect the rationality or the fairness, and I hope, for the reasons I've given, it can have no impact as a matter of domestic law on legality, given that we are in the context that it's not open to the appellant to assert legally enforceable fishing rights under international law. So the tribunal doesn't plug a hole in Mr. Fleming's case, because it's not a hole that Mr. Fleming is entitled to exploit. But even if I'm wrong about all of that, and this court is entitled to look at the award, as my speaking note seeks to show, the only respect in which the tribunal found against the United Kingdom was essentially a procedural one about consultation, and in this context it definitely does mean bilateral and not public consultation, and consultation is a matter of international, not domestic law, and so no direct bearing on this case. The only respect in which the tribunal found against the United Kingdom was failure to comply with its procedural obligations under the articles of the UN Convention of the Law of the Sea in relation to consulting Mauritius about the proposal. But that, in a sense, links back to our point about fairness. and the argument that my argument that Mauritius had every opportunity to put forward its case if it wanted to, but it took the stance it did, because I've just taken you through at some detail and all the materials. So our case is that on no aspect of any public law challenge does the appellant have any case, let alone a strong one, in relation to fishing rights.
Right. Yep.
Right, well, shall I turn then to the next head, which is improper motive. Now, I think logically, the first matter here is the respondent's notice and the admissibility of the cable before we get on to the partially factual question about application utility, using the cable if it is admissible in this case. So can we now turn to the question of the admissibility of the cable, as I'm calling it?
Yep.
And can I ask you to take up the speaking note that I handed on this, because if we do come short of time, this is essentially all I need to say. It's simply a matter of following through the references that are given in the speaking note, but there are a couple of matters that I need to take you to, in particular the two American cases I need to take you to. I don't know whether the court has had a chance to read it, so how fast you want me to go through with this, but if I start and you can tell me to speed up or skip over if you think that I'm taking up too much time on this.
Can I just mention a point which had occurred to me? Admitting a newspaper report which sets out something which a journalist has obtained from a website is one thing. Leading evidence from witnesses as to the authenticity of the reported cable is something distinct. And it occurred to me there might be issues in relation to both of those. Your speaking note, I think, focuses primarily on the first aspect, but I wondered if you might also deal with the second.
I certainly hope it does too, and the respondent has made it clear throughout that we did not object to Mr. Plemming using the articles as a tool for cross-examining Mr. Roberts and Miss Yeadon. Yes, I will address that then in the course. We are dealing with Articles 24 and 27 of the Vienna Convention on the law on diplomatic relations, which unfortunately is not in the bundle. It's in the blue file at tab 3.
Thank you. Yep. Yes.
And we can see Article 24, the archives and documents of the mission shall be inviolable at any time and wherever they may be. And Article 27, paragraph 2, the official correspondence of the mission shall be inviolable. Official correspondence means all correspondence relating to the mission and its functions. Those articles have the force of law by virtue of the Diplomatic Privileges Act 1964, Schedule 1. And again, unfortunately, the copy you've got in the bundle is the Queen's Printer's copy. It's not the current copy, so you need to go to the blue bundle for the current copy.
What is the factual hypothesis on which we should approach this? is it suggested, I mean, that the cable was leaked from the embassy in the UK? I mean, we may not be able to take judicial notice of very much, but it's widely thought to have been leaked by Chelsea Manning from the US end. Does that affect the issue?
My submission, it has no effect whatsoever on the issue. Right. And this court does not, and the courts below have no evidence on who it was or where it was
Well, exactly, but I mean, do we not have to be satisfied that the facts are such that the archives of the embassy or the correspondence of the embassy would be violated by the use of this material in court? And may it not be relevant to that question whether the evidence that we've got is equally consistent with the leak having come from the US end? Or are you submitting that if there is a leak from a US government department which relates to communications from its embassy, the Diplomatic Relations Convention applies to the leak from the central government in the US also?
I draw a distinction between disclosure that is authorised and unauthorised. So if we confine ourselves to unauthorised disclosure, then I do submit that the convention applies equally whether or not the unauthorised disclosure takes place from the mission itself in the receiving state, from elsewhere in the receiving state, or from outside the receiving state.
So do you submit that the inviolability of the documents of the mission extends to the inviolability of records of what those documents say in the hands of the United States government in Washington? You do?
If I've understood it right, my answer is yes, because the same documents can exist in multiple copies, and providing that the document in some form, copy or other, is still part of the archive.
Well, that's the question, isn't it?
Yes.
It might be said that if the State Department in Washington, for example, has got a copy of a cable from the London Embassy, that copy is part of the archives of the State Department. It's not part of the archives of the diplomatic mission. And the diplomatic conventions, the Diplomatic Relations Convention doesn't protect the diplomatic archives of the government itself.
My answer to that is it is both part of the archives of the mission and part of the, whether it's called archives or files or whatever, of the State Department. Right. And both of them have their own claims. I mean, they're both claims essentially by the United States government, but in different capacities. And we'll see the two American cases where applications were made to the American government under the Freedom of Information Act and how they were dealt with as a matter of American law. But all that, in my submission, is entirely independent from the continuing obligations that the United Kingdom owes under the 1961 Convention and the 1964 Act to a document which still remains part of the archives of the mission, notwithstanding that it is also on file, somebody else's file elsewhere.
Isn't that taking, just pursuing this point, taking the scope of the convention a bit outside its opening recitals, which, if one looks at page 2, believe that an international convention on diplomatic intercourse, privileges and immunities would contribute to the development of friendly relations, and realising that the purpose of such privileges and immunities is not is to ensure the efficient performance of the functions of diplomatic missions as representing states. To say that just because a document has been created by a mission and sent from a mission, it remains forever a mission document whereby in diplomatic intercourse, so to speak, and is perhaps pushing it. I mean, well, if it arrives in Downing Street and is considered along with other documents by the Prime Minister, does it retain a special status? in the eyes of other countries under this convention? That's what I wonder.
My Lord, our respect for submission is it's entirely not only consistent, but indeed necessary for the functioning of the convention to do it. And I address this in the speaking note. So can I pick up speaking note at paragraph 16?
Can I just understand how far you take this? You submit, do you, that if a foreign diplomatic mission in London writes a letter to the Foreign Secretary
In London.
That the Foreign Secretary's copy remains part of the diplomatic archives, so that the United Kingdom would be violating the diplomatic archives of the United States mission in London if it published the communications it had received from the United States?
Well, that would depend on the terms in which the letter was written. It is, of course, possible that the letter is expressly written on the understanding, explicit or that the Foreign Secretary is free to make such use of it or not.
That's another issue. There may be other reasons, like the Convention about not disclosing intergovernmental communications, which would militate against disclosure by the Foreign Secretary. But I think it's, as I understand, it's going to be your case that the Foreign Secretary would not be at liberty to publish a communication he'd received from the US Embassy, specifically because that would be to violate the archives of the US Embassy. Is that the submission?
That is my submission, subject, of course, to what may be the important practical rider as to the circumstances in which the letter is written will have an important bearing as to whether or not disclosure is authorised under those terms. But yes, it is at least possible that the letter could be written by the mission in circumstances which, putting it crudely, are confidential, such that if the Secretary of State, the Foreign Secretary, were to publish it, it would indeed be a breach of the Convention.
Would that apply equally to a letter not written from the mission, but written from the Foreign Office of the country concerned?
Well, in that case...
would it be a different standard, even if it was the same letter?
Well, it has to get into the mission's archives in the first place. If it goes straight from the State Department to King Charles Street, I'm not sure it ever comes into the archives of the mission.
Well, doesn't that make
That seems a bit odd. Exactly, yes, exactly.
That rather focuses attention on what constitutes the archives of the mission, and when a document is and isn't part of it.
Yes.
If the mission is in a State Department writes to a letter to the Foreign Secretary with a copy to the mission, is that covered by your argument?
Or it could say to the ambassador, please deliver this letter from the Secretary of State in Washington to the Foreign Secretary. That immediately means it's part of the archives of the mission, whereas if it had passed directly from the State Department to the Foreign Office, the result would be different.
Yes, I accept all of that. If it is within the archives of the mission, the fact that it is also sent to a third party, whether that's the British Foreign Secretary or to the State Department, does not in and of itself cause it to cease to be part of the archives of the mission.
So if you copy in the mission, that's enough?
Well, I'm not sure that I would put it in that bold a term, because even the phrase copy in...
well, you copy them in presumably for a purpose.
It's the logic of your argument, isn't it?
Yes. Accepting your Lordship's qualification, it's copied in for a...
Well, otherwise you wouldn't copy them in.
Yeah, yes. And essentially that, you know, as part of our official functions, we want you, the mission, to put this document on your file in the archives.
We want you to know what's going on.
Yes, yes, yes. Assuming that the reason that the mission is being copied in is because it's intended that the mission should have a copy kept on its own archive, its own file, then the answer is yes.
Well, presumably you couldn't really start examining why it was copied in. You would then get into once it seems to me that your position would almost have to be in practice. Once it's copied in, it's covered by the convention.
Well, that may well be right, but I don't want to make any absolutist position.
I understand that, but the purpose of this is to examine the soundness of the proposition.
Well, that I understand. Well, if I can say then, yes, subject to any special circumstance.
Understand that qualification, yes.
Well, what if the letter says, we don't need you to put this on the file, just keeping you informed?
Well, that was why I was hesitating towards Neuberger, because towards my response to Lord Neuberger, because one can keep tweaking the facts, and sooner or later one comes to a difficult borderline case. I accept that. It's always possible to conduct that exercise.
On your analysis, I suppose it might be the copies which were between foreign ministries might not be covered by the convention. The copy which went to the mission might be. I mean, that's another possibility.
Yes. Yes.
Right.
Yes. So I do address this in the speaking note. Can we pick this up at paragraph 16 of the speaking note?
Yes, of course.
I don't think we need to turn up paragraph 59 of the appellant's case. What I do say is it's surely routine, perhaps universal, for both the mission and its government to keep copies of documents passing between them. Appellant's argument is contrary to the rationale for 24 and 27, but also contrary to authority. And I refer back to the respondent's case, which is in volume 1. This is my chasing all the cross-references back to each other.
223, yes.
Yes, and that is a reference back to Shearson-Lehman. Can I start off Shearson-Lehman in the Court of Appeal? That's Hearing Bundle Volume 7 at 2530.
It's not, actually.
Is it not? Sorry.
That's the House of Lords, I think. Oh, maybe it's after that. Yes, it's 2548, is it?
Yes, the actual page I want is 2569, because I've noted that. Yes, I think... This, I hope, is a Court of Appeal.
Yep.
Yes,
So.
it's 2564 as the start of Lord Justice Dillon's judgment. And at 2569, against number 2, Mr. Justice Webster at first instance appears to have ruled that even if a document is capable of being part of the official archive, a copy of that document is not. I do not follow this. We are concerned particularly with documents that have been printed by the International Tin Council in its own premises, in runs often of substantial numbers of copies. In my judgment, all copies of such a document which remain or are for the time being in possession of the ITC are equally entitled to protection as part of the official archives of the ITC. And then in the House of Lords, it's 2535.
This doesn't help us on the relevant point, does it? I mean, it's obvious that it can't matter if it's in the mission, whether it's a copy or an original document. The question is what happens when it ceases to be in the possession of the mission.
Yes, in the House of Lords, essentially what Lord Justice said in the Court of Appeal was not in any way challenged. So,
But some of the documents in issue in this case had been obtained by Freedom of Information requests addressed to government departments in the United States.
sorry, I'm being sorry.
Is that right?
In our case,
No, in this case that Shearson. Am I right in thinking that some of the documents that they were trying to rely on had been supplied in response to freedom of information requests addressed to government departments in Washington.
I think that's right, though. I don't recollect. Shearson Lehman was unusual in the sense that it was effectively a whole raft of assumed facts rather than any actual findings of fact made. So they were trying to cover off all the different permutations. But it was certainly part of those permutations that documents had legitimately, lawfully come into the hands of third parties. So that would be entirely consistent with what your lordship's just put to me. Returning to the speaking note at paragraph 17, if the existence of a copy of the document on the government file in the sending state meant that the copy of the same document held by the mission was automatically no longer part of the mission archive, missions would in practice have to keep their archives on mission premises, where the inviolability of the documents would not be pursuant to Article 24 but to Article 22. But the words wherever they may be in Article 24 show that that cannot be a correct interpretation of the Vienna Convention. This is in substance the same point that the International Law Commission was making in its commentary. We can find that at bundle 11.
So for example, if one's talking about electronically stored data, which may be held on a cloud server anywhere in the world, you would say that the same principle applies if it's identifiable as an electronically stored version of a document or indeed a communication to or from the mission.
Yes. So the International Law Commentary, volume 11, 4690, and I do actually set this out at paragraph 4 of the speaking note, so you don't have to turn it up. We can just refer to the speaking note. What the International Law Commentary on what became Article 24 says, this article reproduces unchanged the text of the corresponding provision in Article 18 of the 1957 draft. As the Commission pointed out in the commentary on its 1957 draft, the inviolability applies to archives and documents regardless of the premises in which they may be, and that means what it says.
Subject to the question whether they've still got to be the archives of the mission,
yes, I accept
wherever they may be. So it doesn't matter whether the mission keeps its archives in a warehouse in Yorkshire or, for that matter, in a warehouse in Massachusetts, so long as they remain part of the archives of the mission.
Yes.
And not of some other entity of the US government.
Yes, but the reference to archive is reference to the document as opposed to the library shelves. As in the case of the premises of the mission, receiving state is obliged to respect the inviolability itself and to prevent its infringement by other parties. It was suggested that the words and documents in the text should be deleted, and that the statement in the commentary that the inviolability applies to archives and documents regardless of the premises in which they may be was too sweeping. The Commission cannot share this view. The mission's documents, even though separated from the archives, and this is my bookshelf point, and whether belonging to the archives or not, must, like the archives themselves, be inviolable, irrespective of their physical whereabouts, e.g. while carried on the person of a member of a mission. It was for that reason that this extension was provided for in the General Convention on the Privileges and Immunities of the United Nations. Although the inviolability of the mission's archives and documents is at least partly covered by the inviolability of the mission's premises and property, a special provision is desirable because of the importance of this inviolability of the functions of the mission. This inviolability is connected with the protection accorded by Article 25, now Article 27, to the correspondence and communication of the mission. And we can follow that back to the travaux préparatoires, and I give the reference at paragraph 5 of the note. Lord, I'm conscious I haven't got too much time, but if I can ask you to read, it does make good the submission that there was an active debate about this very point in the drafting of the convention. And then paragraph 18 of the speaking note, the copy of the mission document that the mission sends back home to its government may itself be the subject of an application for disclosure. Such application was made on the basis of the newspaper articles which feature in this case. But the fact that there's a document on the file in the State Department does not mean that there cannot be a copy of the same document in the archive of the US mission in London. The legal proceedings concerned in the US concerned only one state, the United States. A US court was considering disclosure of a US document, which is why the application there was determined by reference to US domestic law. The instant legal proceedings in England fall to be determined by reference to the Diplomatic Privileges Act, because a copy of the document in the mission archives remains inviolable pursuant to the 1961 Convention. Mr. Bancoult could himself have filed a Freedom of Information Act request in a US court, which would have been determined by reference to US domestic law, just as in the Unrow case, but that's not what he did. And then the Unrow case also demonstrates that the US government and the US courts attach importance to not authenticating the document. I can either take you to those now, or I'll go back to the beginning, so to speak, of the speaking note, because I was seeking to answer the court's question. Right, well, if we return to the earlier part of the speaking notes, the appellant's case, with respect, we say, is really setting up an Aunt Sally. It's accusing us of trying to find a blue pencil synonym for the term inviolable, but that's simply not the exercise that this court or ourselves are undertaking with respect.
Yeah.
Lord Mance has already referred to the recitals to the convention, so I needn't refer you back to them again. Paragraph 7 makes the point about the state and international law being responsible for the acts of its organs, which include its judicial authorities. And I give a reference there to the International Law Commission draft articles on responsibility of states for internationally wrongful acts, which I think we now have in the blue bundle as tab 8 of the blue bundle. You have the relevant pages.
Tab 10, did you say? Or 8?
Tab 8.
Sorry, 8. So we have that at 8, yep.
Yep.
Yes.
And just for your note, to highlight the most pertinent paragraphs, you find the discussion of Article 4 on page 40, and it's in particular paragraph 6 of the commentary, because that gives a number of citations from case law, and it's all to do with a point which I think is not controversial, about judicial authorities being part of the state, because it's all the organs of the state that are relevant for our purpose. And then paragraph 8, I deal with the positive obligations aspect of the matter, and I refer to the International Court of Justice case concerning United States diplomatic consular staff in Tehran. That's the Iranian embassy hostages case. And if I could ask you to turn that up at volume 8.
Yep.
And if I could ask you to turn first to paragraph 61, which is on three one eight eight.
3188, yeah.
3188.
Thank you.
Conclusion just reached by the court that the initiation of the attack on the embassy on the 4th of November and of the attacks on the consulates the following day cannot be considered in itself as imputable to the Iranian state does not mean that Iran is, as a consequence, free of any responsibility in regard to those attacks. for its own conduct was in conflict with its international obligations by a number of provisions of the Vienna Conventions of 1961 and 63. 63 is the Consular Convention. Iran was placed under the most categorical obligations as a receiving state to take appropriate steps to ensure the protection of the United States Embassy and consulates, their staffs, archives, means of communication. So there's a reference to archives there, and it goes on to cite a number of the articles in paragraph 62, including Article 24. And it says analogous provisions are to be found in the 1963 Convention, and concludes in paragraph 62, in the view of the court, the obligations of the Iranian government here in question are not merely contractual obligations established by the Vienna Conventions of 1961 and 1963, but also obligations under general international law. And then at 67, this inaction of the Iranian government by itself constituted clear and serious violation of Iran's obligations to the United States under the provisions of inter alia Article 24. And at 69, the second phase of the events which are the subject of the United States claims comprises the whole series of facts which occurred following the completion of the occupation of the embassy and the seizure of the consulates. The occupation having taken place and the diplomatic and consular personnel having been taken hostage, the action required by the Iranian government and by the Vienna Conventions and by general international law was manifest. Its plain duty was at once to make every effort and to take every appropriate step to bring these flagrant infringements of the inviolability of the premises, archives, etc., to a speedy end, to restore the consulates at Tabriz, etc., and in general to re-establish the status quo and to offer reparations. And then at 95, which is the dispositif, at page 3216, the court finds the violations by Iran. Paragraph 1, Iran, by the conduct which the court has set out, has violated in several respects and is still violating obligations owed by it to the United States of America under international conventions in force. And 3, Islamic Republic of Iran must immediately take all steps to redress the situation resulting from the events of November 19, and to that end, etc. And the reason I'm emphasising these positive obligations is because it's another limb of the appellant's argument that effectively, once the cat's out of the bag, so to speak, the show's over, if you mix my metaphors. The point about positive obligations is that the obligation to protect the inviolability continues, and in the present context, what that specifically means is that it would be a breach if an English court were to authenticate a document, because that would be a violation. Paragraph 11, I respond to one of the Australian cases cited by the appellants, and I give the references there, but I don't think I need to turn that up now. I'll deal with that in my reply on this if I need to. And further academic support of the positive aspect of the obligations, this is now paragraph 12 of the speaking note, can be found in a number of authors. Volume 8, Murty at 3323.
Right. Yep.
Sorry, 3223. Can't read my writing.
3233.
3223.
3223. I'll get it right eventually.
Right. Thank you. Yes, I see. Yes, we have that.
Yes, so there's a heading on 3224 for inviolability of the archives of the diplomatic mission. The papers of the ambassador are considered inviolable, first as a logical corollary from the inviolability of the mission, and secondly, and more important, if the security of the papers is not assured, it would be impossible for the mission to function. And to come back to the point that Lord Sumption has been pressing me on, this is the functional aspect of it. It doesn't really matter how many copies there exist. It's necessary to preserve the confidentiality of the document in all its copies in order to promote the functions of the diplomatic mission. If the officials of the receiving state are permitted to search the papers of the ambassador and violate their confidential character, he cannot maintain any worthwhile correspondence with the sending government, reporting the conditions within the receiving state as he expected to do. I'll come back to Vattel later. And then the middle of page 3225, inviolability of archives carries two implications. First, the officials of the receiving state should not seize the papers, examine their contents or publicise them. And second, they should take appropriate steps to prevent non-officials from seizing and destroying their confidential character. And the reference in the footnote there is to the commentary that I've showed you a few minutes ago. And then over the page on 382, 3226, second paragraph, the words "wherever they may be" exclude the possibility of the documents losing their privileged character when they fall into unauthorised hands, since these words were added despite the objection of some delegations. Their position was that the privileged character should cease when the documents pass into unauthorised hands, and that's a reference to the Travaux, which, as I say, I've given you the reference to that. And can I just observe at this point that the appellant, in his reply at 74, page 276 of volume 1, takes a sentence out of the following paragraph of Murty in what we respectfully say is out of context. But if I could ask you to turn up volume 1 at 276. And it's paragraph 74 that cites from Murty.
Yes.
And if we look at Murty, I've just read you the paragraph "wherever they may be," and it continues, and this in the following paragraph: in the event of the papers being found outside the premises of the mission, the receiving government can be required to observe the procedure only if they bear marks of identification which indicate their character. If there are no such marks, the sending government will not be able to complain of any breach. The point being made in that paragraph is all about identifying marks. One, that has no factual relevance to our case, because even the newspaper articles have identifying marks. And two, it's not making a point cutting down wherever they may be.
Yes, it omits some rather important words.
So that's one academic, that's Murty. I'm sure he's a professor, but and also, sorry, there's a few more extracts from Murty. At 384, there's a heading Roman 5, inviolability of communication, which is Article 27. So 3228 now in the memory stick. Inviolability of communication. Communication with the sending and receiving governments is the most important function. And this is why it doesn't matter how many copies there are. It's the confidentiality of the communication that matters. And any action on the part of the receiving government to stifle or interfere with it tends to undermine the main purpose of the mission. Communication between the receiving government and the mission was discussed in the chapter on arenas. Next paragraph, policy demands that the receiving government be required not to interfere and not to permit interference with the communication between the diplomatic mission and the sending government. And then finally on Murty, 3232, page 388.
He's described Professor Murty as the doyen of international law teachers in India, with an experience spanning over 4 decades.
Yes, and with genuine respect, one notes that the word doyen or doyenne is used quite commonly in this area of the jurisprudence. 388, Professor McCorkadale is, and indeed Professor Shaw are probably both doyens of a sort as well. I certainly
It has
am
a
not.
specific diplomatic meaning.
Yes.
I don't know what a collective noun of Dianes is, but anyway.
Anyway, 388, so still on Professor Murty, 388, first full paragraph. Inviolability implies that the receiving government should not intercept the communication or interfere with its confidential character and should take all appropriate measures to prevent such interception and interference by non-officials. Then Professor Sato, same bundle, bundle 8, page 3345.
Yes.
Professor Sato by Sir Ivor Roberts, as we see from the title sheet.
Yes. Another Diane.
And then at 1333 on page 3348, I'm afraid on the paper copies the numbering's sort of masked by black lines. I hope it's visible.
Can you tell us who is the author of this particular chapter? Because I think Sato is a collective work now.
I'll ask my experts to tell me the answer to that, but I will answer it. While I'm getting them to do that, 3348, section 1333, freedom of communications. The right of the diplomatic mission to free and secure communication for official purposes is guaranteed by Article 27. Special protection for its communication is in practical terms probably the most important of all diplomatic privileges and immunities. Without the right to send messages in code, without right to be able to rely on the inviolability of the diplomatic bag, embassy cannot properly perform its function of observing and reporting to the sending government, and it will be seriously hampered in the conduct of negotiations on any matter of importance if it cannot receive confidential instructions. But because of the uncertainty of the previous international law on a few points and fear of abuse of wireless transmitters and of the diplomatic bag, Article 27 was one of the most controversial of the Vienna Convention. And then Wouters and others, the Oxford Handbook, still volume 8, 3308.
Can I ask you this? So everything that we're looking at is concerned with documents which are known to be documents falling within the scope of the convention. In the present case, we have no claim put forward by the US government based on the convention. And the UK government's position, as I understand it, is that it neither confirms nor denies that the newspaper articles concern genuine American cables. So, in that situation, how does this whole issue arise of immunity?
My Lord, there are three strands to my answer on that. First, under the Vienna Convention itself, waiver must be expressed, and there's been no waiver. So
that rather begs the question.
Well, I understand why you make the point, but my point is the default position is you respect it unless it's been waived. That's why express waiver is.
It's got to exist for you to respect it. That's the point, I think, being made.
I think the problem that you have is as if we don't know, we're not allowed to know whether these are actually documents of a mission, then how do we confer on them any immunity or inviolability?
Well, coming to the second and third limbs, independently of the Vienna Convention, the United States state immunity as well, which must be respected by the court without the need for the state in question to claim it. Now, the realities of that are it would be odd if the only way to claim confidentiality of a document was to stand up in court and admit that it's actually a document, because you, by definition, have just admitted what you're seeking not to admit.
Can't you rely on the assertion by the other side? I mean, that they assert this is a genuine document. That's the whole basis of their case. So that it seems rather odd that you're being required to prove it was. And on its face it is.
Well, I agree. On the face of the newspaper article,
If it's not a genuine document, it's out. If it is a genuine document, then you don't have to prove it is, because it's being assumed that it is.
Yes, I mean, put it in the other way around. Either there is no document whatsoever,
Exactly.
or if there is a document, and we've only got the newspaper articles to go on, subject to what I'm going to say in a moment, and we've only got the newspaper articles to go on, you just have to look at it on its face, and it's screamingly obvious that it couldn't be anything other than a diplomatic cable, and unless there's reason to think the contrary, and there is none, it's part of the archives.
Haven't you got a different problem though? I mean, you're only able and in a position to assert this because it's sought to be deployed in evidence in this country. But if it leaked in the States, the convention would be completely irrelevant. The convention requires one country to respect another country's mission documents. But in the States, the convention couldn't conceivably apply there. I mean, it's very odd that it applies in this limited context, isn't it?
Well, again, this is addressed in the speaking note. Assume it's leaked in the States and somebody wants to use it in the States.
Yes.
I quite accept, as indeed has in fact happened in this very case,
Yes.
that would be determined by reference to US law. And I'll take you to two cases on exactly that.
Yes.
But if it was leaked in the States, what matters is not where is it leaked. What matters is where is the putative violation. And here the putative violation is in England, and it's the English court doing the violation by authenticating the document. So in the present case, it doesn't matter. Again, this is going back to one of the law assumptions questions. It doesn't matter where the leak occurred. What matters is that a violation will occur in England.
But it does matter whether at the time that the leak happened, it was part of the archive of the mission as opposed to some other part of the United States. The problem really is that the problem is most clearly exposed by the discussion in Shearson Lehman of the position in relation to documents emanating from the ITC, which had a like immunity as a diplomatic mission. Documents emanating from the ITC, which were actually obtained from US government copies in Washington by Freedom of Information requests. Now, Lord Bridge dealt with this exclusively as depending on whether the disclosure in Washington was authorized or not. As far as I can see, nowhere in Shearson, Lehman and Maclean is there a discussion of the quite distinct problem whether a document that is in a government department in Washington remains part of the archive of the mission in London, or in this case of the ITC. There must come a point at which a document, by the process of transmission to others, ceases to be part of the archive, and at that point it may not matter whether, if it's not part of the archive, whether it's been lawfully or unlawfully leaked to a third party.
Well, I've addressed this to a certain extent at all. I mean, both the wording of the convention, wherever they may be, the purposive construction based on the recitals, and I've shown you some of the academic commentary about the need to preserve the confidentiality, which applies equally no matter how many copies there are. But also, counterexample, let's assume that there is a copy of document in the mission archive, and a further copy is made and is posted to Washington, but the dog eats the letter, so it never gets to Washington. Does it cease to be part of the archive, but as soon as the dog eats it, it becomes part of the archive again because the copy no longer exists? And one can multiply the examples.
That's a very analogous case. I mean, if you take the simple case of an American government communication to its embassy in London, which there is then the received copy in the embassy in London. Now, if that is obtained by a Freedom of Information request addressed in the States under US law to the State Department in Washington, it is clear from Shearson Lehman that it ceases, that effectively any immunity has disappeared. because the disclosure was lawful. Now, if you suppose then that you have a situation in which, instead of being disclosed under a Freedom of Information request, the State Department, some official has leaked it. They've leaked the copy of the original which they sent to the London Embassy. Now, that's not a problem, as far as I can see, is discussed in Shearson-Lehman. You say it's functionally necessary for this, irrespective of whether it's part of the archive, provided there's some copy that is part of the archive, it's functionally necessary to treat it as confidential and not as capable of being used in proceedings. But this, on the face of it, strikes me as turning a principle of inviolability of the archive into a general privilege in relation to documents which have at any stage passed through an embassy, and that seems to be a rather different thing.
As I understand the example you're putting to me, although the leak has...
Unauthorised leak.
Yeah, it's taken place in the States, but it's an English court that's been...
in Washington, of a letter that the Secretary of State sent to the ambassador in London.
And somebody's trying to use said document in an English court.
Yes. Now you have to say that's not allowed.
I do say that's not allowed.
Yes.
To remind you, you've only got a quarter
Sorry,
of an hour.
I'm taking up your time now.
Yes. Well, can I then, because I am conscious that these are difficult questions, the two cases I did want to show you in particular, because otherwise it is chasing through the references, are the two American cases which have looked at requests based on the same newspaper articles that are in this case. And they are the American Civil Liberties Union case and the Unroe case. So it's volume 8.
Yes.
Sorry, volume 7, 2712. I'll do them in chronological order. 2712.
Yeah, I think to be fair, I think Mr. Fleming slightly overran, so I think you've got a bit more than talk it up. I think circumstances, the fair thing is to give you at 1 o'clock.
ACLU is decided in 2012. It's a request under the Freedom of Information Act based on the same
Yes.
articles. 2721. In this case, the ACU contends that the 23 embassy cables it seeks in this action must be disclosed because they are already in the public domain after being published by WikiLeaks. ACLU touches this basic contention in a variety of forms, but this much is clear. ACLU has not met the exacting standard demanded by settled precedent. No matter how extensive the WikiLeaks disclosure is no substitute for an official acknowledgement, and the ACLU has not shown that the executive has officially acknowledged that the specific information issue was part of the WikiLeaks disclosure. Although the LCLU points to various public statements made by executive officials regarding WikiLeaks disclosure, it has failed to tender those generalised and sweeping comments to the specific information in this case. That was further developed in the Unrow case, which is in volume 8. Which was 2015. This is page 3101.
Thank you.
And you'll see at 3103, paragraph 1, Unrow is a self-described advocate for the Chagosian people.
Yes.
And then 3104 refers to the Guardian articles. 3106 makes it clear that there is one cable currently and properly classified by the US government. There was an argument that the US government had acknowledged its existence, but that was based on a misunderstanding of the term identical. What was identical was that the State Department and the Defence Intelligence Agency had the same document, not that they were identical with the newspaper articles. And then we can pick it up, B3115, plaintiffs fail to establish the defendants waive the right to invoke exception 1. When information has been officially acknowledged, its disclosure may be compelled even over an agency's otherwise valid exemption claim. Logic behind the exception is that in some circumstances the release of information is already publicly known, cannot be expected to cause damage to national security or disclose intelligence sources. But courts have recognised the limits to this argument because even if a piece of information is the subject of widespread media and public speculation, its official acknowledgement by an authoritative source may well be new information that could cause damage to national security. Consequently, the DC Circuit has established 3 criteria that must be satisfied, one of which must already have been made public through an official and documented disclosure. Although government bears the burden of proving that its withholding of information is justified, plaintiff asserting a claim to prior disclosure must bear the initial burden. Over the page, and to the 3rd criteria, public disclosure alone is insufficient because the information must also be officially acknowledged. And then over the page refers to the US policy, its own policy of neither confirming nor denying. And then at 3120, it quotes the passage I've read you from the ACLU judgment, no matter how extensive the WikiLeaks disclosure is no substitute for the official acknowledgement. Now, what we now know, and what the divisional court didn't know, but what we now know from these 2 American cases is that there is a cable, it remains classified, and freedom of information requests in the United States for disclosure of the cable have both been dismissed. So contrary to what Mr. Fleming told you yesterday, the position is not that we now know from America that the newspaper articles reproduce an authentic cable. Now, that, of course, as we've pointed out, is all decided under US law because it's a US case under the US Freedom of Information Act. But in terms of comity and functionality, it is highly relevant in my submission as to the continuing application of the inviolability obligation under the Vienna Convention. Authentication does cause a violation, and authentication by an English court is a violation by an organ of the United Kingdom state, in my submission. Because of the time, what I will do is I will not go through any more of the speaking note because the references I think are all accurate, but I'll just check our written case because I think I do need to correct some of the references in the written case. So if you turn to volume 1, and if we can pick it up at 218, so the references to the Vienna Convention, you'll have to look to the Blue Bundle tab 3. That's paragraph 11 and 12.
Yep.
In paragraph 25, there's a reference to a passage from Denzer. It's page 162 of Denzer, not 189, and the memory stick number is 3246. And similarly in paragraph 26, it's page 189 of Denzer, and the memory stick number is 3273.
Yep.
And in paragraph 42, dealing with Professor Salmon, at the bottom of page 228, 3290 is wrong, it should be 3294. Right, I think those are the references that I need to correct. So in the remaining time, can I then deal with the other grounds? Ground 1B starts page 241 of the pleaded case. And again, take the references as there. Can I mention the case that Lord Mance referred to yesterday, the decision of the Supreme Court in Eclairs
Yes.
and JKX? I'm conscious that Lord Sumption gave the leading judgment, Lord Mance gave another judgment with which Lord Newburger agreed, and Lord Clark expressed a preference for Lord Mance's version. I'll make sure copies are available to hand out. Yes, it may be convenient to do it now. Because
What's the citation, please?
2015 UKSC 71, only reported in 2015 business law reports at 1395. It's about a corporate raid, to use Lord Sumption's phrase, and it discusses mixed motives. Without going through it all, I commend the distinction between motive and awareness of consequences, particularly as in Lord Sumption's judgment at 17. And 20 and 21. For reasons that most of your lordships are well aware, the point was not fully argued, which is why Lord Mance expressed the reservations that he did in his judgment. I note that at paragraph 20, paragraph 17, Lord Sumption said that analogy with public law might suggest that a decision which had been materially influenced by a legally irrelevant consideration should generally be set aside, and then goes on to explain why the company law provisions that were in issue in that case were slightly different. So the upshot of the case, as I read it, is that there wasn't a definitive ruling one way or the other on whether the dominant purpose would apply.
I think those who didn't agree with Lord Sumption saw considerable force in his view. We were
Yes.
just being a bit more cautious.
Yes.
But
Yes.
as you say, he does distinguish between the private and public law
Yes.
differences, and interestingly adopts the public law formulation, precisely the one you adopted yesterday.
Yes.
Could you just, so we can note it down, remind us what it precisely was?
Sorry, the
Public law formulation.
yes, sorry, it's in
Materially influenced by a legally irrelevant consideration,
paragraph 17.
It's a material influence, so you're very
which is what
wise.
you said.
Yes.
I think that's what I was trying to probe a little bit, precisely what it meant.
And that's paragraph 55.
Yes, is it a but-for test or is it something else? I'm not sure.
Materiality test.
Huh?
It's a materiality test.
Yes, quite.
Yes.
If the consideration was material to the decision,
I'm not sure it's
then
necessary.
the only alternative approach would involve effectively trying to reimagine the decision without one of the integral factors in the decision maker's mind, and that's not normally a process which a court will undertake.
I thought but-for was not uncommon, so we can think about it a bit more, perhaps.
But an important factual consideration in this case, in my submission, is this. My submission is the appellant's case is Mr. Roberts was motivated, had an improper motive. The appellant's case does not identify any fact that was suppressed by Mr. Roberts or was misrepresented by Mr. Roberts to Mr. Miliband, other than his own improper motive. My submission is, in the absence of any suppressed fact, there is simply no scope for Mr. Miliband to have failed to take account of a relevant consideration. And so the case doesn't get off the ground. The other new case, which I'm grateful to Lord Sumption for, Mr. Fleming did refer to this, and it's now in the bundle, which is the Independent Television Commission, and not the International Tin Council case, at tab 9 of the blue bundle. And as we now all have copies, can I just refer to the key passage from Lord Gough's speech? And Lords Ackler, Keith and Larry all expressly agreed. Lord Templeman gave his own speech without commenting directly. But Lord Gough at 316 and the complaint here was that a staff paper which was put before the Commission was slanted, and therefore if the staff paper's authors were improperly motivated, that should be attributed to the Commission. That was what was rejected by Lord Gough. And he says at page 316, in any event, the criticism appears to me to be based upon a misconception. Advisory papers...
Could you give us the page numbers in the copy with which we've been supplied, which is the printout?
Oh, sorry, yes, my lady, I hadn't seen those.
316, that requires some
16 on the top. Sorry, I hadn't seen that pagination.
Yeah. Thank you.
So it's towards the bottom, about 3/4 of the way down, page 16. You'll see there's a 316 that appears, and it's a couple of lines below that.
Thank you.
So in any event, the criticism appears to me to be based upon a misconception. Advisory papers, especially those so brief and compressed as this one, may well place emphasis on points that are considered important and may well tend towards a certain conclusion. But those who draft advisory papers are not decision makers, and they are not performing a judicial or quasi-judicial role. The duty to act fairly is laid not upon the staff but upon the decision maker himself, here the Commission. This particular paper merely formed part of the data available to the Commission to assist members of the Commission in reaching their decision on the basis of the mass of information before them, the knowledge experience they had gained. The reasons upon which the Commission reached its conclusion have been derived from the affidavits, especially of its chairman. In the circumstances, even if there had been significant errors contained in the paper, there is no basis for assuming that those errors would have infected the reasoning of the Commission, which formed its own independent judgment, did not simply follow the recommendation. Time. The other factual thing that I hope might be helpful is if I take you through the decision making on the 30th of March and 31st of March. which in our case is at page, paragraph 94. And to try and put it in chronological order, this is bundle 2, the first document we need to look at.
Yep. Page.
The page of the case is 247.
Yeah.
The first document to look at is bundle 2, 545.
545, thank you. Yeah.
30th of March 1448, Yeadon to Foreign Secretary.
Yep.
Following telecons, I now attach the MPA submission plus consultation document plus possible draft statement. And then the reply at 1806, the Minister, and this is not the Foreign Secretary, this is the Parliamentary Under-Secretary of State, the Minister was grateful for your submission. His inclination is to be bolder in our statement. He does not think it's likely we'll be able to persuade the Mauritians or those fighting the Chagosian cause otherwise, but since the proposed MPA does not conflict with either our position on Mauritius or Chagosian rights, that we should actually decide to go ahead. And then at 548, next day, the 31st of March, you'll see on 549 the previous day submission is sent to Mr. Merton. Mr. Merton, 8:30, presumably Mauritius translated into London time, on 31st of March. Dear Ewan, to be aware of the latest position on Bayat, most stroke all of our recommended changes to the submission got made, which is good. Thank you, Joanne. I think Miliband will be seeing a balanced view of where we stand. I've no idea if he'll follow the recommendation or not. If he does, we'll be in a position to look favourably, looking favourably on the MPA. We'll have to work through issues relating to Chagosian and Mauritius. I think it would be good and would provide a basis for resumption of talks following both elections. If he goes for the park straight away, we'll face problems for you to carry forward, Joanne. Nevertheless, recommended path potentially dovetails well with government and Mauritius position iterated by Boulel during the meeting last week. If Miliband follows the recommendation, you'll need to get straight to Boulel's office. And the recommendation is the 30th of March submission, which I should have showed you as well.
Which is where? 539.
Yes, thank you. That is the submission from Miss Yeadon to Mr. Roberts, copy to the Minister, and I won't take up time with that now, but I do commend it.
One we should read.
Yes, you did read it.
Thank you.
But just continuing with the chronology, so that was 31st of March, 8:30. The next is 5:50.
Right.
31st of March. At 11:47, so that's 551.
Yes.
And this is the private office of the Foreign Secretary now. Private office just telephoned. Foreign Secretary is minded to ask Collins to declare the MPA and go for option 1, full no-take zone. Final decision not yet taken. Foreign Secretary has said that in an ideal world he would like to go for declaring the MPA, spend the next 3 months reaching some sort of agreement with Mauritian government on government's management of the area, but making it clear we'll have 3 months to consult them. If they haven't come to an agreement, we'll go ahead anyway. He's asked for ideas whether the above is feasible, what are the implications. His objective is to find a way to mitigate the Mauritian reaction. Need to get something to him this afternoon. then mislead. And our initial reaction here is that Mauritians, and insisting any MPA deal must deal with sovereignty and resettlement, they will find it hard to backtrack, especially as UK will not be able to move on sovereignty resettlement. Also, Mauritian election, if the Mauritian election is called today, as suggested in an earlier telecon, when will the election be held? And then Andrew Allen at 12:31. I think this approach risks deciding and being seen to decide policy on the hoof for political timetabling reasons rather than on the basis of expert advice and public consultation. That's a very different approach to the one we recommended yesterday and which Foreign Secretary is still considering. 1 and 2 essentially what we've recommended, but without a 3-year timeline. 2 to 6 are elements you would expect, along with others, to be devolved over time. And then the next one, 552. This is from John Merton, 12:45 on the 31st of March. Foreign Secretary should be made aware that timing could absolutely not be worse locally than to declare a full no-take MPA today. The only thing that could darken things further would be any announcement also excluded Diego Garcia from the MPA. This would cause an uproar to be focused on not just us but our US colleagues. Skipping a paragraph, obviously the Foreign Secretary is free to make whatever decision he chooses. But however, I would insist that it be made aware that to declare the MPA today can have very significant negative consequences for the bilateral relationship. Okay. It would be seen by the government to be here in general and PM Ramgoolam in particular as exceedingly damaging timing. So strong advice from Mr. Merton on that. And then at 5:55, there's a further minute from, sorry, that's the further minute, 31st of March, from Miss Yeadon to Mr. Roberts.
Yes.
We've discussed this with the High Commissioner in Port Louis as paragraph 1. Paragraph 4, High Commissioner has asked that the Foreign Secretary be made aware that the timing could not be worse locally, so well, reproducing his thing.
Passing it on, yep.
And passing it on. And then we get, at 5:57, Miss Yeadon, response from the Foreign Secretary's private secretary, Miss Brooker, 31st of March 1755. Joanne, Foreign Secretary, was grateful for your submission and the copy of the report on consultations. He has carefully considered the arguments in the submission and the views expressed during the consultation. He was grateful for your further notes today. He's considered the submission in the light of the High Commissioner's views, given serious thought to different possible options for announcing an MPA. Foreign Secretary decided to instruct Colin Roberts to declare the full MPA on the 1st of April. Then need to be an announcement to this effect. So we then have the proclamation on the 1st of April, which is at 5:63, and you'll see proclamation number 1. I, Colin Roberts, Commissioner for the British Indian Ocean Territory, acting in pursuance of instructions given by Her Majesty through her Secretary of State, do hereby proclaim the establishment for the British Indian Ocean Territory of a marine reserve to be known as the Marine Protected Area. And then in paragraph 2, the detailed regulations governing the said marine protected area and the implications for fishing and other activities will be addressed in future legislation. So the proclamation says nothing about no take. The press release is at 5:59. Press release from the FCO. The Foreign Secretary, David Miliband, announced the creation, today announced the creation of a marine protected area in the British Indian Ocean Territory. This will include a no-take marine where commercial fishing will be banned. Miliband said, I am today instructing the Commissioner. Now, what I hope all those documents show is, one, this really was Mr. Miliband's decision.
Well, on the face of it, Mr. Roberts was acting as on the instructions.
Yes.
That's what it says on its face. Page 563.
Yes.
So in other words, he was a conduit pipe almost. Yep.
That's both what it says on its face, and it's supported by the contemporaneous email chains that I've showed you as well. The other thing that emerges from the contemporaneous email is there's nothing about improper motive stifling resettlement in that at all. Lords, it's just coming up to 1 o'clock. I've been scrambling around to make sure I've done orally what needs to be done orally, as opposed to asking you to follow up the references. This may be a point to catch my breath.
Well, I mean, you say catch your breath, but,
Well, or to call a halt, because
I mean, we've got this afternoon, which is, apart from Mr. Fleming's reply, is at the moment given over to submissions from Professor McCorquodale and submissions from you on the admissibility issue. We've got to finish at 4 o'clock, or I'm not saying precisely at 4, but not long after. It's a matter for you how far you eat into your 30 minutes, ultimately. But at the moment...
Given the discussion this morning, sorry to cut across,
No.
I'd rather hear Professor McCorquodale, because I appreciate that the WikiLeaks point is not straightforward and is a real point of law. I appreciate I spend a lot of time trawling through facts, and you are the Supreme Court.
I appreciate the difficulty. It's not
yes.
meant critically.
No, but
this is a difficult case.
So I'd rather shut up now and then wait to hear what Professor McCorquodale says.
Well, we'll assume that we'll hear then from Professor McCorquodale at 2. But if there are sort of a couple of minutes you feel really important, you want to get across before he's on his feet, that will be fine. But subject to that, we'll hear from Professor McCorquodale at 2 o'clock. Call now adjourned. Thank you.